Hello friends, so in this session we are going to discuss the section B of Law Optional Paper 1, which covers international law. Now, those of you who have gone through the questions in this section also would have found all these questions to be very straight questions, except for one or two, which of course are an aspirant can perform well in those questions if he has got his eyes and ears open as far as development in international law is concerned. Now, almost the entire paper, the section B, we have covered in our exhaustive notes and my book on international law, which was released in July this year. Now, again, we'll see the pattern of the questions, the marks allotted to each question, the most important aspect of this examination, that is the word limit for each question. You have to restrict your answer to those many words only. If you exceed the word limit, you will be penalized. So that's why it requires not only that you should have a thorough knowledge about the contents, but also the art of writing the answer in a very, very concise form so that you don't miss out on any important content relating to the question. And also, you should not write unnecessary or irrelevant things. Right? So today, we are going to discuss the questions which have been asked. Let's start with the friends. So question number 1 has got 5 parts, A, B, C, D, E. Each has got 10 marks and the pattern is same. Answer the following question in about 150 words each. That means the word limit is 150 words. The pattern will remain the same. The initial first paragraph about analyzing if any statement is given in the question, analyzing that statement or the terms which are there. जो terms दी हुई हैं उनको हम expand करेंगे. जो statement दी हुई है अगर, तो statement का meaning निकालने उसमें statement में वो क्या reflect कर रही है statement, ताकि उसका effect बाकी के question के ऊपर पड़ेगा. So the first 50 words that second set of about 50, it's not 50 आपने गिनती ही करनी है, it's just approximate. So the next 50, about 50 words, that is the next part of your answer, the middle part rather, should contain the legal provisions. And in international law, there are very few case laws which are to be mentioned. So wherever they are required, they have to be mentioned. If any ICJ, International Court of Justice judgment is there, if there's any other legal aspect, maybe UN Charter, maybe any treaty, Vienna Convention, etc., that has to be mentioned. And finally, the conclusion is that how you will correlate your contents of about 100 words with the question which has been asked. And that will form part of the conclusion, the last part of your answer. So let's see the first question. Triumph of positivism has reduced an individual to be an object of international law rather than subject of international law. Now, what comes to our mind when we read this question? क्या आता है, हम एकदम से क्या रिफ्लेक्ट होता है कि of course this statement is talking about positivism, theory of positivism, the nature of international law. क्या है? According to positivists, the next part is of this reduced an individual to be an object of international law rather than a subject of it. So, two important terms. One is who is subject of international law? And what do we understand by object of international law? And it says reduced an individual. Focus is on the individual, not on the states. Don't start writing about the states. You can start your answer, yes, states are the subjects of international law, right? But individuals were never supposed to be subjects of international law. When we talk of it is between the international community, how they behave with each other, how they interact with each other, how they have the intercourse with each other, their relationships between the states. So it is not individual oriented, it is states oriented. But who forms the state? Ultimately, it is the individual. Who does the act which sometimes even binds the state? It is done by an individual. So ultimately, we can say, though individual is not a subject, but it definitely affects the individual. The subject is state, but then effect is on the individual. So that is why individual now has been reduced from not being a subject. It has never been a subject of international law. Only the states have been yes. In certain circumstances, we may call, because some jurists say in certain circumstances, individuals are also taken as subject of international law. But that is when we say restrictions are there on defining or putting an individual in the category of subject. Those restrictions reduce the status of an individual from that of a subject to ऑब्जेक्ट, बिकॉज स्टेट को कौन कॉन्स्टिट्यूट करता है? इंडिविजुअल्स करते हैं. और अगर कोई भी रिलेशनशिप में कोई प्रॉब्लम आती है बिटवीन द स्टेट्स, उसका इफेक्ट कहां होगा? इंडिविजुअल पे होगा. तो इंटरनेशनल लॉ चाहे स्टेट पे लगता है, स्टेट इज द सब्जेक्ट, बट अल्टीमेट ऑब्जेक्ट विल बी इंडिविजुअल. टेक द केस ऑफ वॉर क्राइम्स. Individuals do that. Pirates, who are they? They are individuals. But they are also objects of international law. So you can't say they are subjects. Yes. So let us see. Comment on status of individual under international law in the light of the above statement. That means you don't have to keep on writing about the status of individual in international law, but restrict your answer to this statement. समझ आ गया? चलिए अब हम देखते हैं इसका आंसर. It is no longer possible as a matter of positive law to regard states as the only subjects of international law. There is an increasing disposition to treat individuals within a limited sphere. ये आपको लिखना है. So, individuals cannot be straight away taken as subjects, but in a limited sphere as subjects. So, when you put limitations, they cannot be treated as full subjects. They have to be treated as objects, because you will have to write who constitutes states? Individuals. In international law, in certain areas, individuals are also held liable, as in the case of hijackers, pirates, war criminals, etc. So these you have to mention in your answer. So the first part of your answer should be to expand this and clarify this statement. your answer will automatically emerge because the actual question is about the status of individual in the light of this statement. तो अगर आपने स्टेटमेंट को सही से एनालाइज कर लिया पहले पार्ट में, सेकंड पार्ट आपका अपने आप ही आंसर बन जाता है. कोई मुश्किल? चलिए, इन द रिसेंट टाइम ये लिखा है, इन द बिगिनिंग दे वर एक्सेप्टेड एज सब्जेक्ट्स एज एन एक्सेप्शन टू द जनरल रूल. क्या था जनरल रूल? स्टेट्स आर द सब्जेक्ट्स. बट सो number of jurists treated them as objects rather than subjects. Now we come to the recent times, wherein rights have been conferred and duties have been imposed. What does law do? Law करता क्या है? Law gives us certain rights. Law also imposes duties. So here in recent times we see that international law also confers certain rights on us, like right of having not being a stateless person, isn't it? You cannot, no individual should be left stateless. That is the object. Individual becomes the object. That individual should not remain stateless. Some nationality must give given to him. This is what you have to write in this answer, my dear friend, in 150 words. So, pirates, harmful acts of individuals, foreigners, war criminals, espionage, etc. So, you have to give this also. Where it is found? Preamble, Article 1(3). If you remember, okay, fine. Otherwise, don't bother yourself in writing all the articles. Right? Chaliye, let's go to the question number B. Yeah, this problem will come again. 10 marks, 150 words. What do you mean by contiguous zone? Explain with reference to Indian practices on this subject. Right? So it is, first thing is you have to explain what is contiguous zone. ठीक है? And with respect to Indian practice, how we treat Indian practice about the contiguous zone. So this is how it comes. From the baseline, 12 nautical miles is territorial sea, where all the laws apply. Contiguous zone is between exclusive economic zone and this territorial sea, where some laws apply. Right? So this is what we have to mention. That part of the sea which is beyond and adjacent to the territorial sea of the coastal state. So if you remember this figure in your mind, you will be able to answer it. It's a straight question, isn't it? सीधा सीधा क्वेश्चन पूछा गया है कि कॉन्टिग्यूअस जोन है क्या. तो आपको ये भी लिखना है कि 24 नॉटिकल माइल्स भी होगा. राइट? देन क्या करेंगे? Prevent infringement of its customs, fiscal, immigration or sanitary laws and regulations within its territories or territorial sea. Then punish infringement of the above laws and regulations committed within its territory or because territorial sea where all the laws apply. So what are the Indian practices? India has claimed contiguous zone to the extent of 24 nautical miles by enacting, this is one important aspect of, and very interesting aspect of international law. The international law has to be applied by the states by enacting their own municipal laws. तभी तो लगाएंगे, उसको enforce कैसे करेंगे? तो ratification ही नहीं, enactment of the law, their own statute. As we have seen recently, Singapore Convention on Mediation, and now we have the Mediation Act. आया ना अभी 15 तारीख को. So, any convention, any treaty, international treaty, if a state is a signatory to that, they will have to first ratify the treaty and then enact municipal law to enforce that treaty. ठीक है? तो वही यहां किया गया. Section 5 of the Act envisages that contiguous zone of India is an area beyond and adjacent to the territorial waters, and that the zone extends to this. So this is what Indian practice has done. They have enacted, they have adopted the law of the sea, Article 33, where contiguous zone has been limited to 24 nautical miles from the baseline, and that has been adopted by India. Okay? Right. We come to third. Explain the impact of recognition on the powers and privileges of the states. सीधा क्वेश्चन है. किसके ऊपर है? Recognition of state. Impact, if a state recognizes another state, what will be the impact on powers and privileges? उस स्टेट को क्या पावर मिल जाएंगी, क्या प्रिविलेजेस आप एक्सटेंड करेंगे बाय वे ऑफ रिकॉग्निशन? दिस इज व्हाट वी हैव टू राइट इन दिस आंसर. Nothing more, nothing less. So first we have to define what is recognition. A political community acquires international personality by becoming a member of the family of nations. हम एक स्टेट दूसरी स्टेट को कब रिकॉग्नाइज करती है? जब वो ये महसूस करते हैं when they are of the opinion it's a political decision, right? So, when they decide to recognize another state, that means they consider that state, that this state can now, has got the stability, political stability, and can now be admitted into the international community so that they can meet their responsibilities as a state under international law. वो उसके काबिल हो गए हैं, तब उसको वो रिकॉग्निशन ग्रांट करते हैं. राइट? सो वंस रिकॉग्निशन द रिकॉग्नाइज्ड एक्वायर सर्टेन राइट्स, प्रिविलेजेस, इम्यूनिटी. ये ऐसा ही लिखना है आपने. देन व्हाट आर द इफेक्ट्स? राइट? यू हैव टू राइट दिस. आई विल नॉट रीड आउट. करेक्ट? डिप्लोमेटिक रिलेशंस बन जाएंगे. सॉवरन इम्यूनिटी इज ऑल्सो एंटाइटल्ड टू सक्सेशन इन पोजेशन ऑफ प्रॉपर्टी. ये सारे एस्पेक्ट्स आपको लिखने हैं विच आर देयर इन योर नोट्स ऑल्सो. वेरी एग्जॉस्टिव नोट्स. कम टू द फोर्थ वन. Principle, explain the principle of just cogence with reference to Vienna Convention on Law of Treaties. Very, very important convention. इस क्वेश्चन में कुछ नहीं लिखना, सिर्फ आपको इस प्रिंसिपल को एक्सप्लेन करना है with reference to this convention. That's all. Let's see. What is just cogence? It's a fundamental principle of international law that is accepted by as a norm from which no derogation is permitted. They cannot go back. Treaty shall be void if it conflicts with the general principles of international. That means it is, आपको नाम से पता चल जाएगा कि it is talking about treaties, international treaties. But if any two or more nations enter into a treaty which is against the principles of international law, it will be, in the eyes of international community, it will be treated as void. Right? So, Article 53 of this convention, right? This is what we have to write. Okay, so through Vienna Convention, the principle of just cogence has been codified. It has become a part of international law. So you have to mention this. Okay. Now we come to the fifth very important question, in the sense that it is, that's what I said in the beginning. अगर आपने अपनी कान और आंखें खोल के नहीं रखी हुई तो आपको इस क्वेश्चन में तकलीफ होगी, क्योंकि इट इज टॉकिंग अबाउट समथिंग विच इज वेरी वेरी कॉन्टेम्परेरी इन इंटरनेशनल लॉ. क्या है इसमें? इंटरनेशनल क्रिमिनल कोर्ट इज मोर ऑफ ए यूरोसेंट्रिक ऑर्गेनाइजेशन. ये एक टर्म अभी रिसेंटली फ्लोट हुई है. कुछ जूरिस्ट ने इसको कहा है कि जो आईसीसी है, इंटरनेशनल क्रिमिनल कोड जो है, इट इज मोर टिल्टेड टुवर्ड्स, it is adopting certain principles of European principles, which European nations, they follow. And racism is one of them. ICC has been accused by some as following racism. So that is why this term Eurocentric organization, then an international court. An international court should be neutral, should be impartial, should not consider any factors like racism or differentiation or creating any kind of discrimination. Right? So let us see this. Okay, this background of what is ICC, you have to mention this. So, court's jurisdiction. So, this is what we have to pick up from here and write. Why there are accusations? Okay, dominant international institutions, particular place, that is international law come from a particular place and reflect the standpoints of that place. And which place? Europe. Right? Imperial laws, European imperial laws. So that's why I'm saying you have to keep pace with the contemporary topics. Yes.
जैसे ये हेडिंग डाल के पॉइंट में लिखना है, तो ये उसमें आपका पैराग्राफ
में ऐसे पॉइंट्स में लिख लो, जैसे मर्जी लिख लो, आपकी मर्जी है. लिखना है, वो पॉइंट नहीं देख रहा एग्जामिनर देख रहा है आपने कंटेंट्स क्या लिखी है. कैसे मर्जी लिखिए. कई बार आप फिगर बना के भी लिखते हैं. ठीक है, जैसे वो कॉन्टिग्यूअस जोन वाला था क्वेश्चन, तो उसमें आप बना दीजिए फिगर. It will look nice, and the examiner will also have the feeling that you have the basic knowledge of this. You're very thorough with that. ठीक. So question number 1 is over. Let's go to question number. That was question number 5, because वो उसी में 1 to 4 was section A. So section B में जो first question was question number 5. Now we are coming to question number 6, which is of 3 parts. Same pattern जो section A में है वो section B में है. 20, 15, 15. 20 marks का पहला part A, B and C are 15 marks each. And that will decide how many words you can use. अगर ये 20 marks का है, तो maximum you can go to 250 words. Not exceeding that, though it's not written, but yes, this is the norm. Law must be stable, underline, yet it cannot stand still. क्या मतलब हुआ? लॉ बार बार चेंज नहीं होता. लॉ मस्ट हैव स्टेबिलिटी. लेकिन स्टेबिलिटी का मतलब ये नहीं कि इट इज स्टक. इट हैज टू कीप पेस विद द चेंजिंग नीड्स ऑफ द टाइम्स. आ रहा है ना समझ? सो as it needs to reconcile the conflicting needs of stability and change. दोनों में क्या conflict है? Stability में और change में. So you have to maintain, the law has to maintain a balance between stability and the changes which are required due to changing circumstances. And in the fast developing world, the stability appears to have become the casualty. क्या मतलब हुआ इसका? क्योंकि वर्ड सिनेरियो इतना तेजी से चेंज हो रहा है, डेवलप हो रहा है. न्यू रिलेशंस, न्यू इक्वेशंस आर डेवलपिंग. सो स्टेबिलिटी, it is more tilting towards change because to keep pace with the fast development. So this is how you have to. कैजुअलिटी का मतलब क्या हो गया कि उसके ऊपर स्टेबिलिटी के ऊपर चेंज हावी हो रहा है. होगा ही ऑब्वियसली. जब सिनेरियो चेंज हो रहे हैं, सर्कमस्टेंसेस चेंज हो रहे हैं, दैट मीन्स इंटरनेशनल लॉ ऑल्सो हैज टू कीप पेस विद द चेंजिंग वर्ल्ड सिनेरियो, द फास्ट डेवलपिंग वर्ल्ड. Is it clear? Now, differentiate between traditional international law and new international law. What was traditional international law? It all started with what? Customary law. International customary law. Now it is, how it is changing? It is moving more towards treaties, conventions, right? Where nations are coming forward to adopt new norms, create new norms for each other. Okay? So you have to first do this. And second aspect of this is that it was strictly relating to relations between the states only. पहले वाले क्वेश्चन में जाइए जहां इंडिविजुअल को भी लिया गया है. अब इंटरनेशनल ऑर्गेनाइजेशंस आर आल्सो बिकमिंग सब्जेक्ट्स ऑफ इंटरनेशनल लॉ. पहले सिर्फ स्टेट्स होती थी, एंड टू सम एक्सटेंट इंडिविजुअल्स, नॉन स्टेट एंटिटीज आर आल्सो बिकमिंग subjects of the international law. This is how change is coming in international law. तो वो स्टेबिलिटी वाली बात थोड़ा सा पीछे हट जाती है, चेंज उसके ऊपर डोमिनेट करता जा रहा है. राइट? So what is new international law? Norms and rules that have been evolved since Second World War. क्या हुआ था सेकेंड वर्ल्ड वॉर का इम्पैक्ट? आफ्टर सेकेंड वर्ल्ड वॉर वाज ओवर इन अगस्त 1945, क्या बना था सबसे पहले? यूनाइटेड नेशंस. यूनाइटेड नेशंस. अभी एक क्वेश्चन उस पर भी आएगा. ठीक है? देन कंटेम्परेरी मीन्स modern. Contemporary international law can no longer be reasonably presented within the framework of the classical exposition of international law. Traditional, as the law governing the relations between states, but must be regarded as common law of mankind in an early stage of its development. Right? और लिविंग लॉ. लिविंग लॉ क्या होता है? ये लिखिएगा, ये बड़ा अच्छा है, आपके आंसर को वेट देगा. A living law, we also say we have a living constitution. That means it can adapt to the changing circumstances, changing times. Same is the case with international law. Right? Now, not only states but international organizations are also part of modern international law. Even non-state entities, they are part of international law. And to some extent, again, I say qualified statement, to some extent, even the individuals. Right? We come to part B. It is 15 marks, maximum 200 words. Maximum I'm saying, but गिनने नहीं बैठ जाना. अगर आप अच्छी प्रैक्टिस करते हैं आंसर राइटिंग की तो यू विल ऑटोमेटिकली नो कि कितने वर्ड्स आ गए. इसीलिए हम बार बार मैं ये कहता हूं कि आप आंसर राइटिंग की प्रैक्टिस कीजिए. इवन जो हमारे नोट्स हैं, बुक है इंटरनेशनल लॉ की, एवरी चैप्टर हैज गॉट प्रीवियस ईयर्स क्वेश्चंस, और उन क्वेश्चंस को सिर्फ आप करते जाइए, आपका पेपर देखेंगे ऑटोमेटिकली होता जाएगा. सिर्फ उनकी भी ही प्रैक्टिस करिए और उन सबके आंसर आपको नोट्स में भी मिल जाएंगे और बुक में भी मिल जाएंगे. किस पैराग्राफ में इसका आंसर मिलेगा वो भी लिखा हुआ है क्वेश्चन के साथ. राइट? और यू कैन हैव एक्सेस टू आवर वीडियोस. States and entire thing has been, entire syllabus has been covered by us. There is not even a single area. हम तो इतना सा सिलेबस भी नहीं छोड़ते, एक पार्ट भी नहीं छोड़ते उसका. ये सारा, क्योंकि यूपीएससी यू नेवर नो कहां से उठा के क्वेश्चन दे दे. 90s में क्वेश्चन पूछा होगा, वो फिर दोबारा से इस साल आ गया. तो इसके लिए आप ये नहीं कह सकते इतने साल तक नहीं पूछा. Yes, please. Yes, please. Yes, you are audible. You want to say something? Please. Welcome. Chaliye. Right. Am I audible to all of you? That's very important. Right?
Sir, you are audible, sir.
Thank you. Thank you. You are also audible. You are free to ask me any question. Please. So, states.
Sir, I have a question.
Please.
So my question is regarding these statement-based questions only. So if we talk about question number 5, so we can see that the word limit is very less. But when we talk about from question onwards, the word limit is more. So sir, what would be the approach to answer these type of questions? Do we need to stick to the way the statement has been stated? Or can we also analyze as per our interpretation? Because there can be two ways of interpreting.
Yes. Now, yes. Is your question over? Can I address it?
Yes, sir, please.
Thank you. Yeah. So if you look at the question number 5, the word limit is 150 words. Look at the questions. Are they not very straight questions? Mostly, I'm saying, out of 5, I think 4 are very straight questions. 5th question only had a little bit of more, which requires little bit of more explanation. But that can also be done in 150 words. That is the approach of UPSC. If they put less word limit, they tend to ask direct questions, which is visible, which is quite evident from this paper also. But when you move to question number 6 onwards, what you will see, 6, 7, 8, these 3 questions, there the word limit has been increased, so have been the marks. Here you need to write little more expansion of the terms, the statement, and little more explanation. Because they are all explanation-based questions. You have to analyze each and every aspect of that statement. That itself may take about 75 to 100 words. Right? Whereas in that question number 5, it was restricted only to 150 words. But the question was straight. If it is Define what do you understand by contiguous zone? It's very straight. Indian practice, you know, Indian Maritime Act. So you don't have to write much. You can give the complete answer in 150, the given word limit itself. आपको ज्यादा लिखने की जरूरत नहीं, पर यहां पे है, अगर 20 मार्क्स का क्वेश्चन है, you have to explain little bit in more detail, give more examples, state cases if there are any. That's what I said. In international law there are not many cases, but still there are, and very relevant cases, right? So try to have the same framework वही रखिए. पहले एड्रेस कीजिए टर्म्स को, स्टेटमेंट को, फिर लिखिए लीगल पोजीशन. इन इंटरनेशनल लॉ इट मे बी ए ट्रीटी, इट मे बी ए कन्वेंशन, इट मे बी यूएन चार्टर, relevant provisions, then the case laws if any. Then you can also write what are the state's practices on that, right? And then finally the conclusion. तो थोड़ा एक्सपेंशन हो जाएगा आपके आंसर का, और वही क्वेश्चन भी वैसा ही फ्रेम हुआ है. Look at this, let us analyze this. I think I'll illustrate with this answer, and that will meet the requirement of your query. The states show considerable flexibility in procedures whereby they give effect to the rules of international law within their territory. अब मुझे ये बताइए, स्टेटमेंट को जब हम पढ़ते हैं, when we read the statement, just read the statement, don't look at the other part of the question. States show considerable flexibility in the procedures whereby they give effect to rules of international. How states give effect to rules of international law? Through their municipal laws. Through their municipal laws. So states, when they enact municipal laws or adopt international law within their territorial jurisdiction, states have territorial jurisdiction. So if they have to apply the rules, the principles of international law within their jurisdiction, particularly the territorial jurisdiction, they have to enact their own national or municipal laws. And how? The procedure of adopting or enforcing international law in the form of municipal laws. Those procedures have to be very flexible. Take the case of TRIPS agreement. TRIPS agreement was adopted in various IPR laws, intellectual property rights laws, copyright, right? You have trademark, you have patent. So those procedures, what the states have to adopt, must be in conformity with the provisions of the international agreement or treaty or convention. वही होने चाहिए ना. तो कैसे अपने लॉज में चेंजेस लाके या नया लॉ बना के. अभी रिसेंटली मैंने बताया सिंगापुर कन्वेंशन ऑफ 2019, 7th August 2019, adopted in the form of our newly enacted Mediation Act on 15th of September. अभी उसमें रूल्स बनने हैं. So rules will prescribe the procedures, isn't it? Rules which we call as delegated legislation. तो rules कौन बनाएगा? Under the Parent Act, rules will be formed. So there will be a parent municipal law under which rules will be formed by the executive through a process of delegated legislation, and then the rules will prescribe the procedure कि ये जो लॉ है, इंटरनेशनल लॉ के जो नॉर्म्स हैं, प्रिंसिपल्स हैं, ये हमारी जुरिस्डिक्शन, हमारी टेरिटरी में कैसे अप्लाई होंगे. So states have to be flexible about adopting those procedures, Isn't it? Do you agree with this? This is what this question is. States show considerable flexibility in the procedures whereby they can give effect to rules of international law within their territory. यही तो हम बात कर रहे हैं. Right? Come to now what is, this is how you will explain this statement, madam, in about not less than 75 words. Even up to 100 words. Explain this statement as I am saying. Use these words. Use these concepts. Write them in your own language. इसीलिए writing की practice करो. Then come to the main question. Explain the acceptability of norms of international law in India, citing relevant cases on the subject. अब in India तो मैंने अभी आपको 3-4 गिनवा दिए. अभी गिन लिए बात करते करते. अब केसेस भी देख लेंगे. ठीक है, चलिए, हो गया आपका. राइट? So, international law cannot work without the cooperation and support of national legal system. क्योंकि अप्लाई, अगर आपने इंटरनेशनल लॉ के प्रिंसिपल्स को अप्लाई करना है, दे मस्ट अडॉप्ट टू योर इंटरनेशनल, योर नेशनल लीगल सिस्टम, नेशनल लॉज. राइट? Promotion of international peace, security. Give these cases. Yes, we have fisheries case, very important Indian case, where international customary law has been applied, even by the courts, not only through municipal laws, but even the courts have recognized international law. They have recognized customary international law and applied in Indian conditions fisheries cases, for example. Right? This is very important if you read this. International customary rules are ipso facto part of Indian law and do not require incorporation. That means they will be automatically applied by Indian courts. They do not require incorporation into municipal laws. To that extent, ADM Jabalpur case देखिए. If two constructions of the municipal law were possible, the court should give the construction as might bring about harmony between international law provisions and municipal law. There should not be any conflict. The court should avoid conflicts between the two. Right? Nations must march with the international community and municipal law must respect rules of international law. कितना कुछ है लिखने को. मैम 200 वर्ड्स तो कम पड़ जाएंगे. Got it?
Yes, sir.
Thank you. Let's enjoy this paper as you will be enjoying your paper next year 2024. ऐसे ही याद करना वहां भी. चलिए देखते हैं. Indian courts also attribute primacy to municipal law, but they try to avoid the conflict. ये जरूर लिखना है. Okay, come to 6C. How do you distinguish between continental shelf and EEZ, exclusive economic zone? वहां पे क्या पूछा था? कॉन्टिगुअस जोन. अब कॉन्टिनेंटल शेल्फ है. प्रिंसिपल क्या है कि जो लैंड मास है ये सीधा, देयर इज नो ड्रॉप, स्टीप ड्रॉप, इमीडिएट ड्रॉप. लैंड मास slowly, gradually, in the form of a gradient gets into the sea till it reaches the seabed. और उसमें zones बनाए हुए हैं. Like you have 200 nautical miles, up to 200 nautical miles you have got from the baseline, exclusive economic zone. But don't keep on writing only about EEZ. You have to concentrate on distinction between these two. Because continental shelf शेल्फ होता है ना जो ऐसे नीचे जाता जाता है, ठीक है, तो कॉन्टिनेंटल शेल्फ कैन इवन एक्सटेंड बियॉन्ड दैट ऑल्सो 200 nautical miles, but EEZ will be restricted to only where there can be economic exploitation by the coastal state. Got it? चलिए,
Sir, I have a question, sir.
प्लीज.
Sir, my name is Shahrul and I am watching you from Sir Guwahati, Assam. Currently, I am staying in Karol, sir. So, can you hear me, sir?
Yes, yes. Please, Mr. Alam, please.
So, sir, my question is that little bit out of context, but I wanted to ask you, sir.
Nothing is out of context, my dear friend. Whatever comes to your mind, please ask me.
Okay, thank you, sir.
Yeah.
So, sir, few faculties from Karol Bagh or my coaching institute, they told me that law is a not good subject. You are good at GS, but you will not get a good rank by this law subject. So, sir, do you think that we can cross 300 plus mark in this law option?
Why not? See, you don't have to search for examples here and there, my dear friend. Example is in front of you. I was with a non-law background. I didn't have a law degree. In 1986, when I wrote my civil services exam, I had only one chance. First कह लो, last कह लो, जो मर्जी कह लो. First and last. Only one opportunity. I opted for law. In spite of having a non-law background. If you just see, अब किसी की बात मत सुनिए भाई, सिलेबस पहले पढ़िए. सिलेबस में क्या लिखा हुआ है, आप पूरा सिलेबस पढ़ लीजिए, पेपर 1 का भी, पेपर 2 का भी. You will not be surprised that you will realize I know most of this. आपने स्कूल में भी पढ़ा होगा, आपने कॉलेज के कई और सब्जेक्ट्स में पढ़ा होगा. कॉन्स्टिट्यूशन नहीं पढ़ा क्या? रोज ये कॉन्स्टिट्यूशनल प्रोविजन, ये अमेंडमेंट, एडमिनिस्ट्रेटिव लॉज, प्रिंसिपल्स ऑफ नेचुरल जस्टिस, रोज बात करते हैं उसकी. इंटरनेशनल लॉ की क्या अखबार पढ़ते हो? नहीं पढ़ते. इंटरनेशनल रिलेशंस नहीं पढ़ते जीएस के लिए. जीएस 2 पेपर क्या है आपका? सारे का सारा लॉ ऑप्शनल पेपर 1 है, सारा 100%. दिस ईयर if you look at GS2 paper of this year exam 2023, my dear friend, a law student, law optional student can write that answer to entire GS2 paper without even studying for even 1 hour. Environment law, part of paper 2, contemporary subject, plus also part of international law also. Now, आप एनवायरमेंट नहीं पढ़ेंगे क्या जीएस के लिए? जीएस 3 में क्या नहीं आएगा एनवायरमेंट? एंड देन सी, लॉ इज सच ए इंटरेस्टिंग एंड डायनेमिक सब्जेक्ट. इसको पढ़े बिना आपका गुजारा ही नहीं है लाइफ में. देखिए, लॉ ऑप्शनल का सक्सेस रेट देखिए. सिलेबस पढ़ लिया, काफी समझ आ गया दोनों पेपरों में. आईपीसी किसको अच्छा नहीं लगता पढ़ना? सब मर्डर, ये वो, थेफ्ट, रोज सुनते हैं, रोज देखते हैं. थोड़ा सा ज्यादा पढ़ना पड़ेगा. बट इफ यू लुक एट अदर सब्जेक्ट्स, आप उनका सिलेबस पढ़िए, आपको एबीसी समझ नहीं आएगी. यू विल हैव टू स्टार्ट फ्रॉम स्क्रैच. एंथ्रोपोलॉजी ले लीजिए, सोशियोलॉजी ले लीजिए, साइकोलॉजी ले, जो सो कॉल्ड पॉपुलर है, हिस्ट्री ले लीजिए. हिस्ट्री चलो थोड़ी बहुत आपको पढ़नी पड़ती है जीएस के लिए, पर इतनी डिटेल में पढ़नी पड़ेगी कि दिमाग हिल जाएगा. लॉ में देखिए कितना लॉजिकल है, कितना सिंपल है. ये आपको समझनी, आप देखिए, खुद देखिए कितने सिंपल स्ट्रेट क्वेश्चंस हैं. और अगर आप लिखना, आर्ट ऑफ, मैं तो कहता हूं LAW, लॉ इज लर्न आर्ट ऑफ राइटिंग. इफ यू गॉट दिस स्किल ऑफ राइटिंग, अरे आप लॉ में ही 300 प्लस नहीं लाएंगे, आप एस्से भी अच्छा लिखेंगे, आप GS2 भी अच्छा लिखेंगे दूसरों से. इस बार एक क्वेश्चन आया, उसमें लिखा हुआ है मेंशन केस लॉज, GS2 के पेपर में। अब लॉ स्टूडेंट के लिए केस लॉ कौन सी है, तो बाएं हाथ का खेल है। लुक एट सक्सेस रेट, मेरा डाटा नहीं है, किसी और का भी नहीं है, आपके जो आपके सलाहकार हैं या दोज हु आर गाइडिंग यू। लुक एट UPSC डाटा, इट हैज ऑलवेज बीन अबव 10%, यानी कि 100 बच्चों ने अगर लॉ ऑप्ट किया है तो कम से कम 10 सेलेक्ट हुए। और सब्जेक्ट्स का देख लीजिए 6%, मैक्सिमम 8%। लॉ 14% तक गया हुआ है, 14%। एक साल में तो इट वॉज मोर देन 20%। आई गॉट 89th रैंक इन माई ओनली अटेम्प्ट विद थैंक्स टू लॉ। मैं तभी तो कर रहा हूं एग्जाम्पल, तो आप ये रहा आपके सामने है, कर लीजिए अडॉप्ट।
रैंक भी अच्छी
89th, फर्स्ट 100 में आया था भाई, इन माई फर्स्ट अटेम्प्ट। एंड आई गॉट IAS, आई ऑप्टेड फॉर IAS और गॉट IAS। नाउ आई एम रिटायर्ड, पेंशन ले रहा हूं, बढ़िया, ठीक है। सो डोंट हैव एनी सच, डोंट गो बाय व्हाट अदर्स से, डू अ साइंटिफिक एंड सेल्फ एनालिसिस, फिर डिसाइड करिए। सलाह देने वाले बड़े मिलेंगे, अरे इस साल एंथ्रोपोलॉजी में 2000 लोगों ने, बच्चों ने अप्लाई किया, अपीयर हुए, अरे पास कितने हुए? 6%। और यहां अगर हम कहें, लास्ट ईयर आई वाज एनालाइजिंग द डाटा ऑफ लॉ ऑप्शनल, आई आस्क्ड द सेक्रेटरी UPSC, मैंने कहा मैडम आप बताइए, शी इज माई बैचमेट, नाउ शी इज नो लॉन्गर देयर। आई जस्ट आस्क्ड, madam, how many law students have passed this year? He said 180 wrote in the mains, right? And how many got selected in finally services? 18. Exact 10%. किसी और सब्जेक्ट का बता दीजिए। मैं यही कहता हूं, don't go by what others say, do your own analysis. And if you're a law student with legal background, तब तो कोई प्रॉब्लम ही नहीं है। यू शुड नॉट इवन थिंक ऑफ एनी अदर सब्जेक्ट। मेरा तो लॉ सब्जेक्ट भी नहीं था, मैंने तब भी कर लिया। आई हैड लॉ ऑप्शनल इन बोथ प्रीलिम्स एज वेल एज मेंस। हमारे टाइम में प्रीलिम्स में भी होता था, देयर वर 2 ऑप्शनल्स इन द मेंस। माय फर्स्ट चॉइस वाज लॉ। आई नेवर हैड एनी सेकंड थॉट्स, राइट? सो यू शुड आल्सो डू द सेम थिंग। डोंट गो बाय व्हाट आई से। आफ्टर दिस सेशन, go back home, open all this data and then study yourself. Okay.
So adding to that, sir, I also have one doubt because I wanted to ask this, but now it has been taken.
Come. Yes, please.
So, sir, I do agree that the success rate is good when we take low option, but sir, I have also noticed that people are not scoring above 300. I mean, people are scoring 300 if we talk about sociology and so. So I'm just trying to understand what is the reason.
Reason, my dear friend, is very clear. Examiner goes by what you write in the paper. Sometimes you write in such a language that it's very difficult to make out what exactly you want to convey, because your writing skills are not, have not reached that level. But examiner can say, yes, you know it. You have mentioned the points, but you have not explained them. So if you have not explained them, how he will give you the marks? If you have not mentioned the relevant case laws, or जहां 4 की जरूरत है, you have mentioned only 1, right? Or which may not be directly relevant, sideline से आ रहा है, वहां वो आपके मार्क्स काट लेगा। याद रखिए, you attend, if you are not my student so far, I'll invite you to come and attend one of our sessions, my sessions, maybe online or offline, whatever way you want. You'll see how we guide, how I guide you. I don't coach, I don't teach, I only guide. Here also I'm doing the same thing. I'm just guiding you people. How to approach.
Do you have any branches in Karol, sir?
No, we used to have in old Rajendra Nagar. We have shifted to now GTB Nagar, Mukherjee Nagar. Yeah. So you're welcome here anytime. 4:30 to 6:30 is my session. 5 days a week. So you are most welcome. So
But
let
actually, I've watched your books and I've been studying from your books only. And that's the reason I got to know about it. So I've been very inspired by your notes, and I know like the quality is too much. But I was failing to understand why law is not able to score, even though the
Because
questions are very tough.
very right. I have given you the reason. I have also analyzed this. Last year, the topper, the girl who got, I think, 18th rank or something, could score only 284 or 286, something like that. She couldn't cross 300. Now, you can. Why not? If an examiner can give you this much of marks, why not another 14, 15 marks to cross 300 barrier? कोई लक्ष्मण रेखा तो है नहीं जिसको पार नहीं किया जा सकता. किया जा सकता है. The only problem with our students is that we do not practice. Writing की practice नहीं करते answers. वो करना शुरू कर दो. Within word limit, you will be able to write everything which is required in the answer, and no examiner will have guts to cut your marks. I can tell you this much. I have got it. So adopt the same practice. I am passing on the same skills to you people, which I learned and became successful. I also want that you should also adopt the same. मेरे पास तो टाइम भी नहीं था. You people may be having some more time than me. I had only one chance, 3 months, 3 or 4 months. That's all. आपके पास तो फिर भी 1 साल है अभी. Next year 2024 you will have to write. So 1 साल में. See, that's what I say. Those who have read my 2 books, Constitutional and Administrative Law, first book, and second book, International Law, you need not read any other book. I can challenge you. और Law of Crimes की भी आ रही है. Very soon it will be on the shelves. I don't put it on the market. I sell it only online. Because I don't want to waste time on marketing of my books. You are my marketeers. Like you said, I found your books very good. Okay, ठीक है. Tell others. If you like, tell others. If you don't like, tell me. If you don't understand anything, I tell my students, please, मुझसे पूछिए. मुझे बताइए, यहाँ कमी है. और अगर आपको पसंद है तो दूसरों को बताइए. You are my salespersons, okay? Right, I am not in the business of selling books anyway.
Sir, I want to join your test series, sir. I
Please,
want you.
please, we'll discuss some other time. Let us complete this. And then आप आइए या मेरे से फोन पे बात करिए. We'll be talking about that. चलिए. So continental shelf, EEZ is up to 200 nautical miles, but continental shelf may go till it meets the seabed. ये देखिए ना, gradually जा रहा है ऐसे नीचे. This is the shelf, and then it goes and gets into the seabed. This is what we have to learn. That's all. Land mass which extends from continent. Okay? जहां पे कुछ laws where you can explore, use marine resources. ठीक है, ये आप notes में पढ़िएगा. Now we come to next question. 7A. Again, 20 marks. A is always 20 marks, 250 words. Preamble of UN Charter is representative of the aspirations of humanity in ensuring peace and security across the globe. How far have these objectives been achieved by the United Nations? So first you have to analyze this. What is the preamble? What is the objective of United Nations? थोड़ा सा बैकग्राउंड में जाइए.
To maintain peace.
Why? Because Second World War, failure of League of Nations, First World War, League of Nations, then Second World War. So world never wanted another disastrous Third World War. So they all came together on one platform through UN Charter to ensure peace and security. Right? Now you may be saying, some people may say, those who are critical, that after UN came into being, there have been so many wars. Even now we are having Ukraine, Russia war, where NATO countries are also indirectly participating. It is having effect on world economy, it is having effect on world political circle, but still, it has not exploded so far, touch wood, cross your fingers. Thanks to United Nations interventions. It has not exploded into Third World War. These are what you have to write in your answer, my dear friends, because look at this, how far these objectives have been achieved. Yes, the first big achievement is no world war so far, right, since 1945. And then every country tries to resolve the issues. If there are any wars also, they have been resolved. When Iraq invaded Kuwait, United Nations intervened. Iraqi forces were forced to go back. This is how peace and security has been maintained. Isn't it? Don't you agree with this? If you say yes, then write in your answers. This is what the examiner wants. तभी मैं कह रहा हूं क्वालिटी अपने आंसर की इतनी अच्छी बनाओ कि 300 से ज्यादा मार्क्स आ ही जाएंगे, कोई ताकत रोक नहीं सकती.
So we can write about the recent initiatives of Black Secret Trade.
Oh yes, why not? This is what all examples you have to give. तभी तो 250 words है भाई. As she asked, what should we write? You write all this, but relevant, not irrelevant things.
So can we mention UN peacekeeping missions there?
Yes, why not?
Like for certain, like अगर हम कुछ negative answer को failures भी
फेलियर्स को आप थोड़ा मेंशन करिए और उनके जो कामयाबी है, जो सक्सेसफुल ऑपरेशंस हैं, उनको ज्यादा. हाउ दे हैव बीन एबल टू कंटेन ए सिचुएशन, रिजॉल्व ए सिचुएशन which could have otherwise exploded into a major world war. This is what United Nations has been doing. United Nations Security Council, immediately they convene. And sometimes they will put restrictions, they will put sanctions, economic sanctions, other sanctions. There are so many ways of ensuring that, which the United Nations have evolved. Right? Right? Human right. You can write so many things here. And this will improve the quality of your answer. Despite various failures. Right? Write this. अपने वर्ड्स में लिखिए ये सब. Second, 15 marks, 200 words. Reservation in multilateral treaty excludes or modifies the legal effect of certain provisions of a treaty in its application to that state. It is about application of treaties, how they can be modified. Right? Sometimes in multilateral where more number of nations are party to the treaty. Their application may differ with respect to a few states, so they can modify, they can exclude certain parts. It's there in our notes. Detailed answer is given. Explain the circumstances in which reservation. तो रिजर्वेशन इन ट्रीटीज पे पूरा एक टॉपिक है, उसको पढ़िए और ये आपका आंसर तैयार है. राइट? वियना कन्वेंशन लिख दीजिए, आर्टिकल याद नहीं भी आता कोई बात नहीं, वियना कन्वेंशन तो लिख दोगे ट्रीटी के ऊपर, राइट? राइट टू मेक रिजर्वेशन, it is with the state. C. Under what circumstances recourse to force is permissible and justifiable? Very straight answer is given in the notes. When force can be used, otherwise, in international disputes, there are peaceful methods of resolution. Talks, negotiation, other states they help, state practices you follow. There are so many, arbitration hai, conciliation hai, negotiation hai. There are so many peaceful methods. But here you are not talking about peaceful. And सिर्फ याद रखिए किन हालात में force is permissible under the international law. That is under the provisions of UN Charter. UN Charter also says, yes, in these circumstances you can have recourse to use of force. सीधा सीधा आंसर है इसका, तो इसमें तो कोई दिक्कत ही नहीं है. राइट? ये दे रखी है. What are the grounds of intervention? Fine, you have to expand them. Take each point and expand them. Under chapter 7 of the Charter. The purpose is this, to meet the objective of the United Nations, that is, ensure international peace and security. We come to question number 8. WTO provides a platform for agreements. ये है 20 marks का. For agreements amongst its members which form the legal foundation of global trade. So what is WTO? What is this platform? GATT से बना WTO? What was the purpose?
Resolve trade disputes.
Not only resort to how to remove trade barriers, how to have more expanded international trade and commerce. More states come forward and give MFN status to others. Most favored nations means rationalize your tariffs. There are tariff barriers, there are non-tariff barriers. Tariff barriers are about the customs and other duties, taxes. Non-tariff barriers are about the laws. How you will promote that? So the objective was to promote that. And the second objective, of course, as you said, resolution of international trade disputes. What else do you want in this answer? Tell me, if you write all these aspects. Now, critically evaluate the importance of WTA in new international economic order. ये आपका एक पूरा टॉपिक है, पढ़ लीजिए नोट्स में, बुक में भी है. New World Trade Order, New World Economic Trade Order, something like that. So it is written here. Objectives of WTO, you have to explain in the statement. Global trade में legal foundation, because what gives it a legal foundation? It's a treaty, binding treaty. Treaties are binding. Pacta sunt servanda. याद है? Treaties are to be respected, followed by the nations who sign them. और nations कब sign करते हैं? By way of consent. They give their consent to certain aspects which binds them. And anything which binds them has got a legal force. Right? चलिए. Okay. I studied this particular subject in my life in detail twice. When I did MBA in International Business from Indian Institute of Foreign Trade, और उसमें तो international business है, तो WTO, GATT were most important things. And second, when I did my LLM, rather thrice Master of Business Laws from National Law School, Bangalore. All during my service, I have learned this. And that is reflected in my book. In very simple language, you will find this. लीजिए, ये थोड़ा सा ऊपर नीचे हो गया. 8B, 15 marks, 200 words. Member states of the UN need to take appropriate action for protecting and improving human environment. अब ये हो ही नहीं सकता कि environment पे क्वेश्चन ना हो. कभी सस्टेनेबल डेवलपमेंट पे आ जाएगा स्टेट क्वेश्चन, कभी इस पे आ जाएगा कि मेंबर स्टेट्स को क्या एक्शन लेना चाहिए टू improve human environment. In light of above statement, highlight the major steps of the UN for protecting human environment. क्या मुश्किल है? Various treaties. सबसे पहले कौन सी हुई थी? Stockholm 1972 on environment. Most important treaty. And then thereafter there have been so many steps taken by United Nations. Climate change के ऊपर, sustainable development के ऊपर, यूज ऑफ आउटर स्पेस के ऊपर, यूज ऑफ सी के, लॉ ऑफ सी के ऊपर है. देयर आर सो मेनी ऑफ देम. एयर पोल्यूशन पे है. यू कैन कीप ऑन काउंटिंग देम डिपेंडिंग ऑन योर, बट डोंट मिस आउट द मेजर वंस. राइट? 1972 Stockholm. Then several conferences and programs relating to improvement. There have been so many: biodiversity, high seas treaty, climate change, sustainable development. बहुत कुछ है लिखने को. Only thing is go through the notes and the reading material, whatever is available to you. चलिए, we'll come to the last question. 8C. International humanitarian law is a set of rules to limit the effects of armed conflict. अब इसमें देखो, इसमें पहले पार्ट में उन्होंने इंटरनेशनल ह्यूमैनिटेरियन लॉ के ऊपर IHL कहां पे ऑपरेट होता है, व्हाट इज इट्स स्कोप. देन कम्स द ह्यूमन राइट्स, seeks to ensure a set of rights which are essential for being a human being. The difference between the two is clearly laid down in our notes. Clearly. Right? Distinguish between. So first, expand this, explain IHL, explain human rights, how they are important in international law, and then distinguish between the two. Contents and purpose, because their purpose is different. Human rights are there to ensure your dignified life as a human being. ठीक है? It has a much wider scope. Humanitarian law is when there is an armed conflict and human beings get affected. Maybe prisoners of war, Geneva Convention. There are so many things to write in that. And it is clearly distinct. They operate in different fields. There may be some overlapping, which you can see in the notes. Right? Scope is narrower than human rights. Definitely, human rights talk about much larger aspect. during war and armed conflict. Jabki human rights are always, they have to be generally applied. Okay, so friends, second part of paper 1, that is section B of paper 1 is over. Do you have any doubts? Anything to ask me? You are welcome.
So,
Yes, please.
the lecture, likewise, the questions were asked on mostly on this law of the seas, right?
Huh.
So next year, sir, will that same pattern will follow?
What is to be followed? Can you please repeat your...
Pattern will be followed. Likewise, the questions on law of the seas were asked. No, sir, many questions were asked.
Yeah.
So we have the same pattern.
Sir, it is purely the choice of examiners, UPSC. Sometimes they may ask more questions from one particular area of law. Sometimes. So it keeps on changing. That is why I always insist, इस एग्जाम में कुछ भी आप डिस्टिंग्विश नहीं कर सकते, ये इम्पॉर्टेंट है और ये अनइम्पॉर्टेंट है. यहाँ सब इम्पॉर्टेंट है. किसी साल किसी में ज्यादा क्वेश्चन आए, किसी में ज्यादा आ जाएंगे. सो यू कांट अफोर्ड टू लीव एनी पार्ट ऑफ द सिलेबस. सिलेबस इतना है भी नहीं आपका भाई. और ये अगर आपने कर लिया, आपका इंटरनेशनल रिलेशंस भी काफी हो जाएगा. इंटरनेशनल ऑर्गेनाइजेशंस पे इस बार ज्यादा क्वेश्चन नहीं आया, कोई भी शायद क्वेश्चन नहीं है इसमें इंटरनेशनल ऑर्गेनाइजेशंस पे ऊपर. बट यस, समटाइम्स दे मे आस्क मेनी क्वेश्चंस ऑन इंटरनेशनल ऑर्गेनाइजेशंस अलोन. तो इसलिए यू कांट जनरलाइज, यू कांट reach any inferences, you can't draw any inferences by going through previous year's questions. ये बहुत लोग करते हैं ऐसे और वहीं पे प्रॉब्लम आ जाती है. They will say, ये इतने साल क्वेश्चन नहीं आया, don't do it, read it from the reading material. अरे वहां से इस बार आ जाएगा, अगली बार आ जाएगा. क्या करेंगे स्टूडेंट वहां पे? They will remember you in the examination hall कि सर ने बोला था ये इंपॉर्टेंट नहीं है. मैं कहता हूँ सारा इंपॉर्टेंट है. द एंटायर सिलेबस इज इंपॉर्टेंट फ्रॉम दिस एग्जामिनेशन. इसीलिए तो ये वर्ल्ड का नंबर 1 एग्जाम है. और जो इसको पास करेगा, इंडिया की क्रीम कहलाओगे आप. पता नहीं, अब आई एम नॉट पार्ट ऑफ दैट दिस थिंग. मैं अपने आप को क्रीम कहलाना पसंद नहीं करता. बट यस, पीपल दे से यू विल गेट द बेस्ट ब्रेन्स. व्हाई? बिकॉज ये नहीं कि वी आर टॉपर्स और वी आर समथिंग. आई हैव नेवर topped in any of the courses throughout my life, from school, college, anywhere. I have 5 master's degrees, 2 in law, 2 in management, 1 in public administration, all from top academic institutions. But I have never topped in any course. I have never topped in civil services also, bhai. I got only 89th rank. I was not in the first 3 or 2 or 1. But yes, your reading, your studies must serve the purpose for which you are making this effort. उसमें succeed होना है, उसमें कामयाब होना है. Okay? So we will take in our next session paper 2 section A. We'll start with law of crimes, law of torts. First वो वाला part करेंगे. Then we'll do law of contracts and mercantile law and contemporary legal issues, covering the entire paper 2, maybe in 2 sessions, right?
Sir, I have one last question.
Please.
Sir, I was reading your book, so when I have read your books, I have noticed that in the clause, the facts have been stated. But sir, do you think it is advisable to write the facts of the case in the answers?
Very relevant question. Never write facts in your answer, you will be losing words. What examiner is looking at is facts are written in the books or notes just to make you aware. इस केस में क्या हुआ था? And then you can relate it to the concept which has emerged out of it. Write that concept in the answers here. Don't write the fact. Don't make this mistake of writing facts. Because sometimes the facts are given in the question itself. You have to write only the relevant part, operative part. हम पढ़ते हैं ना, इतनी जजमेंट्स आती हैं कोर्ट से. What we do? We don't go through the entire 1,000 pages or 900 pages or 200 pages, whatever. We move to the operative part. Yes, to familiarize ourselves with the topic, we may have to read the facts also. How these facts led to this inference, this result. Okay, so don't please mention any facts, or if at all they are asking, they will never ask. Have you seen any question where facts have been asked? चाहे वो कॉन्स्टिट्यूशनल लॉ का था, एडमिनिस्ट्रेटिव लॉ का था, या आज इंटरनेशनल लॉ का था. So they will never ask you facts. They'll ask you, they'll test your knowledge about the concepts. That should be clear. And you should be able to quote the relevant cases, relevant provisions of law. No facts are required in this examination, at least. Right? If there are no more questions.
Sir, and also the year should be avoided while.
If you can remember the correct year, then only write. If you remember, try to remember, because there are not many cases. Like if you say environment कहाँ से शुरू हुआ, 1972 Stockholm से, क्या difficulty है? You have to remember only a few of them. But if you don't write the year, don't get disheartened. Mention the right case, the relevant case. The name should be correct. And don't develop the habit of, quoting the year. Sometimes वो तो citation तक लिख देते हैं कुछ तो. ठीक है, अगर आप याद कर सकते हो करो, पर examiner will not appreciate that. Examiner will appreciate your how much depth of knowledge you have on that particular topic, whether the conceptual clarity is there or not, and that should reflect in your answers. Right? So friends, thank you very much.